And all eyes are now on what the South African government will do next to get Shepherd Bushiri and his wife Mary back into the country. Government says it is invoking a SADC Extradition Protocol. The Bushiris fled South Africa for their home country, Malawi, last week while they were out on bail of fraud and theft and money laundering charges. Government says it has started the extradition process to secure the couple's return to South Africa. So what does this SADC Extradition Protocol entail? Let's speak now to Professor Tseli Phooko, an associate professor in the Faculty of Law at the University of Johannesburg. Also joining us is retired Deputy Director of the Public Prosecutions at the NPA's Johannesburg office, Advocate Johan du Toit. Professor Phooko, let's start with you. What does the SADC Extradition Protocol entail?
Good morning and good morning to the viewers. Well, the SADC Protocol on the extradition, of which South Africa and Malawi have signed and ratified, it provides the procedure for the extradition of an individual who has been accused of various crimes, including money laundering. So under Article 5, the protocol lays out the procedure wherein it shall be written and addressed through diplomatic channels by the state which is requesting same from the state wherein the accused is currently based. So it looks quite easy, the procedure in the treaty, but the difficulty, in my view, is the implementation. For example, if you look at the SADC protocol and the South African laws, those are two independent, separate legal systems. Even though South Africa has ratified the SADC protocol on extradition, from the research that I have conducted, it does not appear that such protocol has been domesticated in the South African laws. In other words, it does not form part and parcel of our legal system. Then that's where the legal process might have problems. But assuming that the diplomatic channel, as envisaged by the treaty, is pursued and there is no legal challenge maybe by the accused, Bushiri in this case, then that might a well-convenient process. But if Bushiri challenges such extradition on the grounds that South Africa has not incorporated a legislation to give effect to the SADC protocol on extradition, we might have a serious problem there. So far, the diplomatic channel looks quite easy, and the countries have, for a good part, enjoyed very good diplomatic relations. So the possibility at this stage, it appears that, well, the chances are quite huge that he might be extradited in South Africa together with the wife. But should a legal challenge arise, there might be a problem.
Advocate du Toit, from the South African side, what kind of paperwork would the NPA be involved in to ensure the extradition is successful for someone whose real identity is so questionable?
Good morning, everyone. Yes, I think before you get to the papers, I think what the prosecution will probably do first is to apply to the court for the bail to be forfeited, and then ask the magistrate to rule that a warrant of arrest be issued for both of their arrests. That is normally, a first process that will have to follow before you start with your extradition proceedings. Now, surely the legal team for the two fugitives will dispute that, and they will also place information in front of the court, which they're entitled to do so. And then at the end of the day, the magistrate will rule, and to say that whether there's a case been made out for a warrant of arrest to be issued. Now, once that warrant of arrest has been issued by the court, that will form the basis for the extradition application. Because normally when you apply for extradition, you must at least have a warrant, because the other country can see that there is in fact a case before you. Now, there's two options that you can follow. The first option is that you can ask for provisional arrest. That's normally in a case of urgency, that you go through Interpol to Interpol, you give a brief description of what the facts are all about, normally signed by the Director of Public Prosecutions. In this case, it will be the one in Pretoria. And then that application is then forwarded with the warrant through the Interpol channels, and then Malawi will be requested to arrest the two fugitives. If they do so, then the formal application, where you basically set out your case, will have to follow within 30 days according to the treaty. So this is the one way. The other way is that you can also do a formal application through the official channels and do a formal application where you have to set out your case against the other accused, so that the other country can see that there is at least a prima facie case against the two fugitives. And then once they receive that application, normally the arrest will follow, and then the facts will be placed before that magistrate in Malawi, which will consider it. It was normally a two-phase approach. Many countries work like this, also us in South Africa. There's first a legal decision, whether there's a prima facie case against it, and once that is made, then it becomes a political decision. Then normally the Minister of Justice must rule whether or not they're going to extradite these two people to South Africa, and then they may also set some conditions. That is normal in any sort of extradition. So that is, in a nutshell, the process that will follow.
Yeah, although the Minister of Justice has already indicated some appetite to extradite when he showed the protocols the other day. But Prof, before I ask you the next question, how do we say your name?
Tseli.
Oh, okay. So it is Tseli. All right. So I was right.
Yes.
I was worried about that. All right. How much weight does this extradition treaty carry for SADC member countries?
Well, it's a quite a progressive piece of legislation, which seeks to address issues of such as the current case. And I can assure you, depending on the implementation of it, though, in my view, largely lies on the political will. So if the two countries are willing to give effect to their treaty obligations, then we shouldn't have a problem there. It's quite an important piece of legislation.
Yeah. All right. We're having a conversation with Professor Phooko and Advocate Johan du Toit about the possibilities, possible scenarios in the Bushiri case. But we might be crossing to Port Elizabeth any moment now. I'm just waiting for my producers to indicate when the right time to do so is. But for now, we'll continue with this conversation. Prof, let's bring you back into the conversation. What if a member state refuses to honor such a treaty? What sanctions could be imposed?
Well, the sanctions are not that clear, basically. Then the member states will have to go back in the form of, in this particular case, the SADC summit will have to sit down and hold the state of Malawi accountable for having failure to give effect to their treaty obligations. So it could be diplomatic isolations or any other, measures that the SADC summit will deem it fit to hold Malawi accountable.
Yeah.
But let's hope that it doesn't really reach that stage, because once it reaches there, it altogether shifts from the legal perspective and falls into the political, a very problematic political process, which is unpredictable.
All right, let's cross quickly to the Port Elizabeth High Court, where the Omotoso case, today's proceedings are taking place. A judgment in the application brought by the state to make amendments to the indictment against Pastor Timothy Omotoso will be heard in the court this morning. On Friday, the court heard final submissions from the state and defense in the application. Omotoso, who faces charges of rape and human trafficking, was denied bail for a third time. He and his two co-accused, Lusanda Solani and Zukiswa Sito, are facing facing more than 90 sex-related charges. For more on the story, let's now cross live to our colleague Veronica Fourie. Veronica, very good morning to you. What can we expect from today's proceedings?
Good morning from the Port Elizabeth High Court. Yes, the defence will still continue today to argue that they object about against the changes that were made to the indictment. They say that would only cause more charges against the Mr. Omotoso, and they are not happy that the evidence which the two previous witnesses gave in court are still in the indictment. They say they want it removed. Now, that has not been concluded yet. The arguments will continue this morning in court in front of Judge Irma Skuman. Now, our listeners might remember that we first had Judge Makaula, who had to recuse himself from the case, and while he was the presiding officer, we heard the evidence of Cheryl Zondi. And then the case was taken over by Judge Irma Skuman, and it was in front of her that the two women also gave their evidence. Now the defence wants that to be removed. So Judge Irma Skuman will have to listen to the final arguments regarding that, and we hope that she will make a call on that later this morning.
Thank you for that update. We'll be watching to see as proceedings begin and see how that turns out. Let's go back now to that conversation we were having earlier with Professor Phooko and Advocate there. Advocate du Toit, let's come to you now. You know, the Prof was speaking earlier about the non-binding or, nature of these protocols. What if the Bushiris don't come back? What then?
It's, unfortunately, countries, they work according to treaties. If you don't have a treaty, you can use the international recognized principle of comity. It means good neighborness. We part of SADC. Malawi is a neighbor of us. So, sometimes even if there's no treaty, you can use that principle as a backup and say, but okay, we part of SADC. We recognize that we're neighbors. Let's talk this thing through and do that. Unfortunately, if that doesn't work, you cannot just go into another country and snatch the guy and bring him back. That's
okay, Advocate, I'm going to have to ask you to hold on to your thoughts there. It's one of those really busy news days, but we're just going to